Have you ever stopped to think about what happens if, just maybe for a moment, you can't speak for yourself? Or maybe you're suddenly unable to manage your own finances? Or make those really crucial healthcare decisions? It's definitely not a pleasant thought, is it? But, preparing for life's unexpected turns is, well, it's just smart planning, being truly well-informed. And that's exactly why today we're taking a deep dive into the power of attorney, or POA as you often hear it called. This isn't just some dry legal form. It's actually a really powerful tool. Think of it as your personal safeguard. It ensures your wishes are honored, your affairs are managed smoothly, and importantly, your loved ones are spared a lot of unnecessary burden during, really difficult times.
Exactly right. At its core, a power of attorney lets one person, that's the principal, that's you legally grant another person your agent, or sometimes called an attorney, in fact, the authority to, well, act on your behalf. This can cover your financial world, your healthcare decisions, or, as is often pretty wise, both. For seniors, definitely, people planning retirement, but frankly, for anyone wanting to proactively prepare for potential incapacity, it's not just a good idea. It's really a vital part of a comprehensive life planning strategy.
Okay, so let's unpack that a bit. What's the real benefit here? The game changer, maybe? And I guess on the flip side, what's the immediate fallout if you don't have one of these documents ready?
hmm The game changer is really about control and continuity. Without a POA, your loved ones, they could find themselves stuck in a really lengthy, incredibly expensive, and just emotionally draining court process just to get a guardian or a conservator appointed. Think about that. Bills are piling up, medical decisions might be delayed, and this is all happening while your family is trying to navigate a crisis. A POA basically sidesteps all of that and makes sure bills get paid on time, care isn't delayed, and crucially, you get to decide who makes these calls for you, not, some judge. It provides undeniable clarity, too. Your wishes are written down, documented. That drastically reduces the potential for family arguments or confusion. Plus, there's remarkable flexibility built in. The powers you grant can be as broad or as limited as you need. They can be immediate, or they might only become effective when, say, a specific event occurs.
Wow, that paints a really powerful picture.
Huh.
So practically speaking, what does this mean for us? Let's maybe talk about the different flavors of POA, because you mentioned it's not really a one-size-fits-all deal.
You're absolutely right, not at all. We mainly talk about two big categories: financial power of attorney and healthcare power of attorney. So the financial POA, that's all about empowering your agent to manage your money, your property, other assets. And this can be incredibly broad. We're talking about everything from, paying bills and managing bank accounts to filing taxes, buying or selling real estate, handling investments, your retirement accounts, even applying for government benefits like Social Security. It's quite comprehensive.
Okay, and here's where I think it gets really interesting, maybe a bit confusing for people.
Yeah.
The variations within those financial POAs. Can you tell us about durable versus springing? Those terms seem really important.
They really are. They hold a lot of weight. So a general financial POA gives broad authority, sure. But here's the critical point, especially for long-term planning. It automatically ends if you, the principal, become incapacitated. Unless it's specifically written to be durable. And that's where the durable financial POA comes in. It stays in effect even if you become incapacitated. This is why it's really the cornerstone for most people's planning. It provides that continuity we talked about.
Right, so durable means it lasts through incapacity. Makes sense.
Exactly. Then you also have what's called a limited or special POA. That's, well, just like it sounds. It's for very specific tasks or maybe a limited time frame. Like, say, signing documents to sell your house while you happen to be traveling abroad. Very specific.
Okay.
And finally, there's the springing POA. This one only activates or springs into effect when a specific future event happens. Usually that event is your incapacity, and it often requires confirmation from doctors. It's like setting a condition that needs to be met first.
Got it. Like a tripwire almost.
Yeah, that's a good way to think about it.
Okay, so that's the financial side. Now, what about the other side of the coin? The healthcare power of attorney.
Right. Also known by a few different names, you might hear healthcare proxy, medical POA, or maybe advanced healthcare directive. It all points to the same thing. This document designates someone specifically to make medical and personal care decisions for you, but only if you can't make them yourself. Their authority can cover things like choosing your doctors or healthcare facilities, consenting to treatments, or refusing them, including those really difficult end-of-life decisions, especially if it's combined with something like a living will. And accessing your medical records. That's a big one. That last point is key for HIPAA compliance.
Ah, IPAA.
Right. Yeah, that's the Health Insurance Portability and Accountability Act. It protects your medical privacy. Your agent needs specific authorization in the POA to get access to that information on your behalf. But the crucial distinction here is that a healthcare POA focuses only on your medical and personal well-being. It doesn't touch your finances.
What seems really powerful, though, is the synergy you get, like a real power-up when you have both, a financial and a healthcare POA working together.
Precisely. It's about having that comprehensive coverage. Imagine a medical crisis hits. Your healthcare agent is making the critical decisions about your treatment plan, while at the same time, your financial agent is making sure your medical bills get paid, your mortgage payment isn't missed, basically keeping your financial life running as smoothly as possible.
So they work in tandem.
Exactly. It avoids court intervention completely. It preserves your economy because you defined your wishes up front. And honestly, it provides just immense peace of mind for you and for your family during what are already incredibly stressful times. It's like having, both sides of the shield protecting you.
Okay, this leads to a really important question, one I know a lot of our listeners grapple with. Who do you actually pick? Who do you choose for this incredibly important role of agent? It's certainly not a casual choice, is it?
Oh, not at all. Choosing the right agent it's paramount because this role carries significant legal and moral responsibility. The person you select must, first and foremost, be trustworthy. Absolute honesty, integrity, these are non-negotiable. They also need to be competent. Can they understand potentially complex financial statements or maybe complicated medical information? They have to be available, willing, and able to actually act when needed, which could be on very short notice. And particularly for healthcare decisions, they should deeply understand and ideally be aligned with your personal values and wishes.
So who do people usually choose?
Well, many people opt for a spouse or an adult child, maybe a close, trusted friend. But, professional fiduciaries or even attorneys can also serve.
Yeah.
That might be an option if you prefer complete objectivity or perhaps don't have a suitable family member or friend. And remember, agents act as fiduciaries. That's a legal term. It means they have a legal obligation to act only in your best interests. They have to avoid conflicts of interest, keep really meticulous records of what they do on your behalf. It's a high standard, a very high bar.
Okay, so let's say you've picked your agent, you've got the documents signed. How do they actually work? How do they go into effect in the real world?
Right. So once they're properly signed and executed following your state's specific laws, which is crucial, a POA generally grants your agent the authority detailed in the document pretty much immediately, unless, of course, it's one of those springing POAs we talked about.
Right.
For financial POAs, that often means the agent can act right away if needed. For healthcare, the authority typically only begins when medical professionals determine that you're unable to make or communicate your own decisions. And it's important to know banks, hospitals, other institutions, they'll often require the original document or at least a certified copy. So keeping it somewhere safe but accessible is really key.
But, with such great power comes great responsibility and I guess sometimes real risk, too. What are the potential pitfalls here? And maybe more importantly, how do we safeguard against them?
That's a critical point, absolutely. A POA does grant significant authority, and it definitely can be abused if the wrong person is chosen. It happens. We've seen situations involving financial exploitation, unauthorized transactions, even cases where medical choices are made that go completely against what the person would have wanted.
Scary stuff.
It is. So mitigation strategies are crucial. You can, for instance, appoint co-agents. May be required that they have to act together jointly for significant decisions. That adds a layer of checks and balances. You can also set very explicit limits on the powers you grant within the document itself. Spell out what they can't do.
Okay.
Or you could require that your agent provide periodic accountings or reports to another trusted person, maybe a sibling or an accountant. But frankly, the most important mitigation strategy goes back to your initial choice. Select an agent with a proven track record of integrity, sound judgment, and unwavering loyalty to you. That's the best protection.
Okay, so let's make this really practical for our listener. How do you actually go about creating one of these? What are the concrete steps someone should take?
Sure. The process really involves several key steps. First, you need to take stock. Figure out your needs. Do you need a financial POA, a healthcare POA, or, as is common, both? Second, very carefully select your agent or agents, and this is critical. Talk to them. Confirm they're willing to take on the role and that they understand what it entails. Don't just assume.
Good point.
Third, articulate your wishes. Define the powers you want to grant clearly and specifically within the document. Be precise. Fourth step is drafting the document itself. Now, while you can find generic forms online, ideally you'll use state-specific forms. Or even better, have an attorney prepare it. This helps ensure it fully complies with your local laws, which can vary quite a bit.
Right, the state law variations.
Exactly. Fifth, you have to sign and witness it correctly. Most states require the signing to be notarized and often witnessed by one or two people who aren't your agents. Follow those rules strictly. Sixth, distribute copies. Give copies to your primary agent, any backup agents you've named, your main healthcare providers, and relevant financial institutions like your bank.
Right.
And importantly, keep an original document in a secure place, but somewhere it can be found easily when needed. Not locked away so well that no one can get it.
Yeah, accessibility is key.
Definitely. And finally, this isn't a set it and forget it kind of thing. You should review your POAs regularly, maybe every few years or whenever major life changes occur. Update them as relationships change, laws evolve, or your own circumstances shift.
That makes sense. What about changing your mind? If you decide you picked the wrong person, or your circumstances change drastically, or just generally, when does a power of attorney simply end?
Good questions. As the principal, you absolutely can revoke or cancel a POA at any time. The key condition is that you must be mentally competent when you do so. This revocation should always be done in writing. And you need to send copies of that written revocation to your agent and any institutions, like banks or hospitals, that have the original POA on file to make sure they know it's no longer valid.
Okay, so a formal written notice.
Yes. And if you want to make changes, say, name a different agent or alter the powers, it typically requires creating an entirely new POA document. Usually don't just amend the old one. As for when a POA ends automatically, well, it always terminates when the principal dies. At that point, your will or trust, if you have one, takes over management of your estate. It also ends if you, the principal, revoke it while competent, like we just discussed. Or, if it was a limited POA for a specific task, it ends when that task is completed. It could also end if the agent resigns or becomes unable to act and you haven't named a successor or backup agent. And finally, a court could potentially invalidate it, although that's less common if it was properly drafted and executed.
This brings us back to something you touched on the legal side, especially how state laws can be so different across the country. That seems like a potential minefield.
It really can be if you're not careful. State laws do vary significantly. They have different rules about the exact form the document needs to take, the execution requirements, like how many witnesses, or if notarization is mandatory. Even how POAs from other states are recognized can differ. Wow.
For instance, some states are very specific about the exact wording you need to use for a POA to be considered durable. If you miss that specific language, it might not hold up during incapacity. Overlooking these seemingly small details, these formalities, can potentially invalidate the entire document, no matter how clearly you thought you expressed your wishes.
So attention to detail is critical.
Absolutely. For healthcare POAs, it's particularly vital to include language specifically allowing your agent to access your medical records. That's crucial for HIPAA compliance, as we mentioned. Without it, they might hit a wall trying to get information. Also, always name successor agents. What if your first choice is unavailable, becomes ill themselves, or predeceases you? Having backups is essential. And finally, make sure your POAs are coordinated with your other estate planning documents, your will, any trusts you have. They should all work together consistently, not contradict each other. A lawyer can really help ensure that alignment.
Okay, to sort of bring this all home, maybe make it less abstract, can you give us just a couple of quick real-world examples of a POA in action? Sure, absolutely. Let's take a financial POA first. Imagine, say, an elderly person who's starting to have some mobility issues, maybe finding it hard to get to the bank or manage paperwork. They authorize their daughter using a durable financial POA. She can then step in to manage paying their monthly bills, handle property taxes, maybe oversee investment accounts, all according to their instructions. It keeps their affairs running smoothly.
Okay, that makes sense.
And for a healthcare POA, consider a man who's scheduled for major surgery. He designates his spouse using a healthcare POA. If during recovery he's unconscious or unable to speak for himself for a period, his spouse has the clear legal authority to make immediate medical decisions based on what they know he would want. Consent to procedures, talk to doctors, etc.
Right.
These aren't just, theoreticals. These are everyday situations where having these documents in place provides truly invaluable support and clarity. It removes so much potential stress.
And that leads us right to the final, really crucial point. Why planning early, even when you feel perfectly healthy and invincible, is just so critical.
Yeah, it's because waiting until a health crisis hits often makes establishing a POA incredibly difficult, if not completely impossible, especially if the person's mental capacity is already starting to decline or is suddenly impaired. The window for being able to legally sign these documents can close very, very suddenly.
You might miss your chance.
Exactly. Planning early, designating your agents while you are clearly competent, ensures the document is valid. It ensures your wishes are unequivocally clear. And most importantly, it means you maintain control over your future, even if you can't voice your decisions later. It also alleviates just an enormous psychological burden on your family, allowing them to focus on your care and well-being, not scrambling to deal with legal hurdles and financial messes.
So after this deep dive, what really stands out to you, listener? We've covered a lot of ground on power of attorney. It's complex, no doubt, but hopefully we've managed to make it a lot clearer.
Yeah, if we try to connect this all back to the bigger picture, I think the key takeaways from our conversation today are pretty clear. First, remember the two main types: financial POA for money and property, healthcare POA for medical decisions. Know the difference. Second, that durable aspect we discussed, it's vital. Durable POAs remain effective even if you become incapacitated, making them absolutely essential for effective long-term planning.
Hmm.
Third, your choice of agent is just paramount. Select someone you trust completely, who is competent, available, and who truly understands their profound fiduciary duty to act only in your best interest. Fourth, those legal formalities really matter. Always follow your specific state's requirements for signing, witnessing, notarization. Don't cut corners there.
Crucial.
And finally, remember, this isn't a static document. Regular reviews are a must. Keep it current with your life, your relationships, and any changes in the law.
Ultimately setting up these powers of attorney for both financial and healthcare matters, it really is one of the most proactive, compassionate, and truly important steps you can take, both for your own personal planning and for your estate planning. It's fundamentally about taking control of your future, protecting your interests, and ensuring real peace of mind for yourself and, frankly, for everyone you care about.
And maybe this raises one last important question for you, the listener, to consider. Beyond just having the POA document signed and filed away, how might clearly communicating your values, your deeper preferences, maybe your specific expectations, now actually talking to your chosen agents, how might that further reduce stress down the line? And how can it help ensure that your wishes are truly honored, even in the most difficult, perhaps ambiguous circumstances? Think about those crucial, maybe sometimes unspoken conversations you might need to have.